Good evening. Over the decades during which I have made these presentations, they have always been in person. We are now experimenting with presentations by Zoom, and maybe you as participants are more comfortable with this. I am surely not, but I intend to try to deliver some information to you with the very, very good assistance of my associate, Karina Espinoza. We're going to cover some topics, and we're going to try to answer some questions. We have a small law firm. When you listen to both of us, you will have listened to all of the attorneys in our office. It is an estate planning law firm, but within the scope of estate planning, we have come to specialize over these last 35 plus years in the needs of families with mentally ill and with mentally handicapped family members. Usually we meet with parents, and they come to talk with us about planning challenges for children or a child. Sometimes we meet with siblings, and sometimes we end up representing children of adults who struggle with mental illness and were under control at different times, but at this point are not, or there's planning needs that they're concerned about. Celia told me, and we know this, that these topics are of great importance to you as NAMI members and as NAMI families. And we know that. We know that not because we've met with you individually, but because every family that has come into our office in these 30 plus years quickly makes us understand how important it is to you. The information we're going to talk about today covers the area of guardianship, and our goal is to provide you with some information that you will then take to an attorney, your attorney, an attorney who you choose in the community, to talk about guardianship and to make decisions about guardianship if it's needed in your situation or if it's not needed, if there are other strategies, if there is already an existing guardianship, how can it be used effectively, what can be done to make it less of a burden and more of a benefit, and are there strategies to add on to a guardianship or enhance a guardianship proceeding. For the most part, we're going to talk about how guardianship is handled in Miami-Dade County. Other counties in our state handle them differently. That may come as a surprise since you were under the impression we're all part of the state of Florida, but in fact, how each court organizes guardianships does seem to be different from state to state and from county to county, and surely from state to state, but from county to county, there are differences that are generally the source of irritation more than anything better or worse. They just, you bump into these changes. I want to move ahead into the list of topics that Karina and I want to cover. I don't think you'll know everything you need to know about guardianship when we're done, but I want you to know, we want you to know a certain number of things. First of all, you should understand that the guardianship issue for mentally ill adults is a small fraction of the world of guardianships, and that the laws of the state of Florida are not written for guardianships of mentally ill adults, and that the procedures in each county are not devised for the application of guardianship law to mentally ill adults. Far and away, most guardianships in Florida are older people who have assets, who were competent to manage their affairs, did manage their affairs, but because of illness or old age, became incapacitated, and someone, we hope someone with good intentions, but occasionally someone without good intentions or with bad intentions, has stepped up to become guardian. When there is no planning, guardians may be needed even for the most simple task as paying a bill. But guardianship law is biased heavily towards dealing with these folk and not to answering the questions of how will this work for my 37-year-old son who is struggling with bipolar disorder, or my 38-year-old daughter who suffers from severe depression. We in this office end up making things up in the law as best we can to solve problems with the guardianship laws and tools and procedures and the problems that our families present to us. We do not do guardianships very much. We have a couple of older people who have assets and were competent. We specialize in these types of guardianships, and we have many, many guardianships of mentally handicapped and many, many guardianships of mentally ill adults that we handle. But we really work with the entire family and the family's needs. But you want to know about guardianships. And when I get a call from a family, I ask some questions, and I want to share those questions with you because they're relevant to your thinking. One of the first questions, it's a threshold question, is your child over the age of 18? Because until your child turns 18, you, a parent, and I'm assuming I'm speaking to parents, you, the parent, are the natural guardian of your child, and you do not need a legal proceeding to become guardian of a 16, 17-year-old child, no matter how problematic their behaviors or psychiatric condition is. You are the guardian. For reasons we won't discuss, when that child turns 18, on that child's 18th birthday, that child becomes a legally competent adult with all of the rights of a legally competent adult in the state of Florida. The problems that child presents on the 364th day of their 17th year and the problems that child presents on the first day of their 18th year may be exactly the same. The level of competence may be exactly the same, a functional competence of how things work out there in the real world. But our laws make everybody a competent adult at age 18. So I ask, is this individual older than the age of 18? Can this individual make important decisions? Maybe he or she can, particularly when we work with adults with mental illness. That's an important question. What important decisions are a problem? What's the problem? Does this individual need the protection of a guardianship? We talk about guardianship as a way to protect, as a way to shelter an adult from some of the things that can go wrong in the world. We ask, is there or are there medical issues that a guardianship can help with? As you know, some of your adult family members have non-psychiatric medical issues. They're being treated for one sort of medical problem or another, and a doctor or a facility may be asking for a guardianship because that doctor or facility may not be comfortable providing services, treatment, information for your adult child after the age of 18 without a guardianship. Every case is different. Do you need a guardianship in order to apply for benefits and services? Most families think that you need to have a guardianship in order to apply for SSI disability when a child turns into an adult or at any later date. And that is not the case. Social Security is a federal program and does not require state-appointed guardians. You can make your way through Social Security and Medicare and Medicaid without being a court-appointed guardian. But there are lots of other places in getting services and programs and assistance and housing where a guardianship can be key. So we ask that question as well. And finally, sometimes we are asked, or we ask, are you being asked by anyone to be guardian? We surely had something in the last few weeks where a family called and said, the social worker at the facility is asking us to become guardian. Well, this was, I get my cases mixed up, but the adult is in a voluntary placement out of county and not taking her medication. Not taking her medication, just sort of hanging out in this voluntary facility. And the facility says to the parents, you need to be appointed guardian. So I talked to the parents and I said, go back and ask what difference it would make if you were guardian. If you were guardian and you signed a letter that says we as guardian require the facility to, I guess the letter would say, we require our daughter to take her medicine. What would the facility do? Would they hold up the letter and say, look, here is the letter your parents as guardian sent. You have to take the medicine. And why would she take it? Why would that be persuasive? I asked them to ask the facility how this was going to work, and I have not heard back. That's how we get started. And then we listen. We do a lot of listening, and we then talk about what kinds of guardian options are out there. And we're going to listen to Karina for a minute about that.
Yes, so I'll be going over the types of guardians that are available here in Florida. So there's two general categories of guardians. There are natural guardians and there are guardians that are appointed by the court. As Mitchell mentioned, natural guardians are the parents of minor children, whether they are their naturally born children or adoptive children. Then there are guardians that are appointed by the court. Before I go into the types of guardians that are appointed by the court, I'm going to briefly discuss the process of how to be appointed as a guardian by the court. So the first step is you need to file a document with the court called the Petition to Determine Incapacity. This document will be, this document states that you are asking the court to inquire into the capacity of this individual that you believe needs a guardian. In addition to this petition, a guardianship application, a guardian application is filed with the court along with fingerprints. The guardian application has background information on the people who would like to be appointed as guardian, and the fingerprints are for background screening. Once these documents are filed with a court, the judge then schedules a hearing on this petition to determine incapacity and also appoints an examining committee. The examining committee, it consists of 3 members. Most of them are either psychiatrists or physicians. And those 3 members of the examining committee then individually meet with this alleged incapacitated person in order to prepare a report to the court on their recommendation on whether a guardianship should be established and what type of guardianship should be established. So once those reports are filed with the court, typically shortly after that, that's when the hearing comes, and the judge will take into account the documents that has been filed with the court. That is the petition to determine incapacity, the guardian application, and the guardian's fingerprints, along with the examining committee reports. At that hearing, the judge determines whether a guardianship should be established and whether the people that are petitioning to be guardians will be appointed as guardian. So now I'll go into the types of guardians. So first, there's the guardian of the person. A guardian of the person is needed when someone cannot care for themselves and they need help to care for themselves. So in this case, a guardian of the person is appointed by the court in order to manage the personal affairs of that incapacitated person and to care for that person's physical and personal needs. There is also a guardian of the property. A guardian of the property will be needed if this incapacitated person cannot manage their own property or their own finances. In this case, the guardian of the property would be appointed in order to manage and protect this person's finances and assets. So in addition to a guardian of the person and property, there's a second step. It's determining the amount of authority this guardian of the person or guardian of the property would have. So this is done by determining whether a plenary guardian is needed or a limited guardian. A plenary guardian is needed when the court determines that this individual, the alleged incapacitated person, lacks the capacity to do all tasks that are necessary to care for themselves or for their property. And for their property. So in a plenary guardian, all rights of that person are removed, and there are certain rights that are designated in the Florida statute that are delegated over to the guardian that is appointed. So an example of those delegated rights are the right to contract, the right to apply for government benefits, the right to determine the alleged incapacitated person's residence, to manage property, and to consent to medical or mental health treatment. There are certain rights that will be removed from this incapacitated person, but cannot be delegated over to a guardian. And those type of rights include the right to marry, the right to vote, and a right to have a driver's license. So in addition to a plenary guardian, there are also limited guardians. A limited guardian will be appointed by the court when the court determines that this incapacitated person lacks the capacity to do some, but not all of the tasks that are necessary to care for himself or for his property. So of those delegable rights that I previously mentioned, not all of those would be removed from the incapacitated person. Only some of them will be removed as determined necessary based off of the needs of the incapacitated person. And then those rights would be delegated over to the guardian. So in addition to guardian of the person, of the property, and the different types of authority, the plenary guardian and the limited guardian, there's another type of guardian that seems to confuse people. So they are called guardian advocates. To make it even more confusing, there are two types of guardian advocates. The first is under Florida Statute Chapter 393. This type of guardian advocate is involved in a special type of guardianship proceeding for a person that has a developmental disability and they lack decision-making ability to do some, but not all of their decision-making tasks. So in this case, a guardian advocate will be appointed for this person with a developmental disability, and they will be the one to take over for the decision-making tasks that the incapacitated person, the person with a developmental disability cannot manage on their own. The second type of—
Before you get to the second type, I want the particular audience to understand that you may be asked about guardian advocates, and you may be asked about the proceeding that Karina just described, but for reasons that are in the law, this only applies to people with developmental disabilities and does not apply to people with mental illness. As much as it might make sense to apply, it does not. And that there's historical reasons why it was done the way it was done, but we don't have the ability to get around it.
Yes. So the second type of guardian advocate is a guardian advocate in a Baker Act proceeding. Baker Act proceedings are under Florida Statute Chapter 394. So when a person is Baker Acted and sent to a facility or a hospital, if the physician or psychiatrist determines that that person is unable to make medical decisions for themselves or to consent to treatment that is needed, then that physician or psychiatrist will then ask the court to appoint a guardian advocate to be able to assist during this urgent matter where the patient will need to, the guardian advocate in this case will need to consent on behalf of the patient or discuss any medical treatment that needs to be done for the patient. So now that we have a little bit of background on the types of guardians, we'll talk about who should serve as guardian. First, in Florida, any Florida resident who is 18 years or older and has capacity, they are able to serve as guardian for someone. So it doesn't have to be a relative, a family or friend, anybody that is a Florida resident, 18 years or older and has capacity. If you're a non-resident of Florida and you're seeking to be appointed as guardian for someone in Florida, there's a restriction that non-Florida residents must be a close close relative to this alleged incapacitated person. So that would be either a spouse, a brother or sister, an aunt or uncle, niece or nephew. Typically what we see, and maybe other firms see as well, is that most of the time family and friends, if they are around and able, they are the ones best suited to be guardian for their friend or for their child or loved one, typically because they have their best interests in mind, and they also know the needs of this alleged incapacitated person and how to best help them based off of their needs. So in addition to family and friends, there are other options when family and friends are either unable to serve as guardian or there's no family or friends around. There's public and professional guardians. Public and professional guardians in Florida are managed by the State Office of Public and Professional Guardians. I believe Mitchell briefly mentioned that public guardians are available when there are no family or friends able or willing to step up and be guardian, and the incapacitated person does not have enough funds to pay for someone to serve as guardian. A professional guardian has a few more qualifications and requirements in order to get that title of professional guardian. They are also managed by the state office, and they're required to do some coursework and an exam to maintain their registration as a professional guardian, and they also receive compensation when they are serving as professional guardian. So Mitchell's going, now that we know a little bit about guardians, Mitchell's going to discuss alternatives.
Back to me. One more thought on the choice of who should serve that is often arises with families who have family members with mental illness, and that is the potential conflict that can arise in a guardianship arrangement. If you're initiating a guardianship, you are, as Karina explained, taking rights away. The court, particularly these days in Miami-Dade County with our current group of judges, are inclined to treat this as an adversarial proceeding in many ways. You against your child, and that can be a problem. And so we have to evaluate who would be guardian as part of this overall question of should there be a guardian? And that is a difficult aspect of this. So even when there is family available, it may not work right. It may not be right to serve as guardian for a sibling or a child. And it's really a case-by-case determination. Overall, and because of what I just explained, we are very reluctant to seek a guardianship for an adult with mental illness who is functioning cognitively, intellectually at a normal or better than normal level. The problems are not inability to communicate. The problems are not inability to go to the store or pay the bills. The problems may be judgment. The problems may be attention to things that need to be paid attention to. And those are serious problems, but we ask, can we solve those problems in ways short of initiating a guardianship? Now, you may already have a guardianship, and I don't know all of you, I only know a couple of you, but you may already have a guardianship. And so alternatives to guardianship, you may say, well, that doesn't apply to me anymore. We already have a guardianship. But I would ask you to listen anyway, because number one, you're talking to other parents and other families. And number two, you may have something to say about these alternatives because you may have tried them and you may know when they did not succeed in meeting the needs that you had in working with your child. And frankly, third, there are certain situations where some of these alternatives to guardianships can still be relevant. The first one, we have used this, and we have used it for adults with mental illness who are on board and on the same page and understand that family members may need to act for them when there are problems, and that is a power of attorney type of document. We have in Florida, in every state, there is something called a durable power of attorney. That's a power of attorney that's signed now while you have capacity, while you're competent. And then if at some point you are not competent or you do not have the capacity to make important decisions, that power of attorney remains in place. It is durable. And there are durable power of attorney documents for financial matters, durable power of attorney documents for health and healthcare management matters, and durable power of attorney documents that are specific to dealing with the government on benefits, dealing with real property issues, dealing with any number of things that you can design it for. Durable power of attorney documents, and all of these alternatives have to depend on the person to whom these alternatives are being presented. So if the person to whom, or the agency or the business or the government agency that you are handing this durable power of attorney says, no, I need something stronger, I need something more reliable than this durable power of attorney, you may be kicked back to a guardianship. There is a model being used in the community called shared decision-making. That is an excellent model. It is for adults who are high functioning and on the same page and want people to be in the picture to help, and they want to control that arrangement, and you enter into a shared decision-making agreement. And that agreement governs who can help and when and what for. We've learned a little bit about this, and I have to say it is essentially the same thing we've always done, but didn't have a label for. It's to work out an arrangement that things could be accomplished and help could be obtained. And I would even recommend this concept in many guardianships. There's no reason why a shared decision-making agreement or an agreement of any sort could not be sculpted and entered into between you, the guardian, and your child, who is the ward, what we call the person whose rights have been taken away in the guardianship. And that might be a good way of adding to a guardianship. There are in Florida documents called healthcare advance directives. These are the documents by which individuals ask someone else to make medical decisions. You ought to have these for yourselves, but your adult child with mental illness might need those as well. Who will make treatment decisions, who will make consent to medical care decisions for them. If there's a guardianship, then these are precluded and they're not available. But if there is no guardianship, this is a way of planning for the need for someone to make decisions. Even then, we cannot always get documents signed. We cannot always get the level of insight and cooperation that allows for a plan. So we work with families who are really trying to handle things through monitoring and oversight, through putting their name on bank accounts so that they can have access to information about funds, to limiting funds that are available to an adult who might give that money away, might take the money out and not know how to use it. We once had a mentally ill adult beneficiary. He wanted pocket money every week or every month. It's hard to remember. It was many years ago. And the trustee of the trust would provide that pocket money. When he had to be moved out of the facility where he lived, it was a boarding house / assisted living facility that I'm pretty sure is gone now, which is good. We found a plastic bag in his closet with all of that cash rolled up and in rubber bands that he had accumulated for several years, hundreds and hundreds of dollars that he didn't really need to spend. But we had tried to create an allowance so that we controlled what was available to him. We want to listen to you and listen to your descriptions of what your adult child can do, what your adult child is successful in doing, and to try to build on those competencies to come up with a structure. If we can create a way of create a working relationship, not a way, but a working relationship and a working structure from a legal point of view, then we can avoid the need for guardianship and the stresses and strains that guardianship causes. But in some cases, we cannot avoid the need for a guardianship and we have to go forward. I've already mentioned one of the most significant limitations to the authority, the practical authority of a guardian. It says on paper, it says in the law that the guardian will make medical decisions for the ward. That means that a decision to require compliance with a medication regime is within the authority of the guardian on paper. But I'm often in that position of saying, you've come here to tell me that you need a guardianship because your child's not taking her medication, your child is not attending the monthly meetings at the community mental health center for an injection. They refuse to stay on their medications, and you've been through this before. You know there'll be a spiral down. You know there'll be Baker acts ahead. There'll be deterioration. You know, as your friends and peers have told you, that it will have to get worse before somebody will step in with long-term hospitalization, somebody being the court. So why do we have to go through that? We just could be guardians and we could then make that decision. The right to make that decision would be delegated to us. But my question is, how will you, on a practical basis, force your child to take those pills? What will you be able to do as guardian, even with a capital G as guardian, that will make your child take that medication or go to the mental health center for those injections? There are limitations to what a guardian can do. You do not have the authority to tie your child down to a table and ask the doctor to inject the child with a medication. And the doctor won't do that. Even if you did have the authority to tie the child down, the doctor won't do it. And I wouldn't do it if I was a doctor. That just isn't going to sit well when you're trying to explain that to a law enforcement authority. But there are decisions by guardians that can be made effectively and successfully. And those include accessing government benefits. If there's a complicated government benefit situation, a guardian can step up, not only make those decisions, make those applications, deal with eligibility issues, but also control the funds that are provided to the adult as guardian. There are decisions in treatment in hospitals, maybe not psychiatric treatment, but all kinds of other medical treatment issues. Some of them the result of trauma, some of them the result of just needing to have healthcare sorted out for them. Information and records. Lawyers cause this problem, and now we have to get involved in solving the problem. Your child goes off to a facility and the doctor says, I won't speak with you because you do not have authority, and your child is not prepared to sign a release, a HIPAA release, to give you authority to talk to me, and I'm sorry, I cannot talk to you. But you need to know something. You need to know when their discharge is planned. You need to know what kind of discharge is planned. You'd like to know what kind of treatment is taking place. Sometimes, in the particular mix of facts, a guardianship is a good idea for that purpose. Not always, but sometimes. What we know is that each situation is different. The experience of the family in working with different providers has been different. The providers that are on hand at this moment, going back to the questions I presented at the very beginning, is there a provider who is saying you need to be guardian? And can we get around that? But if we can't, then a guardianship may need to be initiated. There is no standard answer for adults with mental illness. And adults who are higher functioning and present with those difficulties in the community are even more difficult in the context of guardianship law. They may be difficult all around, but they are surely difficult in fitting their needs into this ill-formed guardianship context. We do our best. We try to make it a least restrictive alternative within the requirements of guardianship law. And guardianship law does have its own set of requirements, and Karina is going to cover some of those at this moment.
Yes, so once you determine that alternatives to guardianship aren't sufficient for the alleged incapacitated person and the court appoints you as guardian, there are some planning requirements by the court that the guardians must follow. So the first one is annual reporting. Each guardian is required to file an annual report with the court. For example, one of them is for a guardian of the person, they must file each year an annual guardianship plan with the court. This annual guardianship plan reports on the ward's activities, their social environment, and their medical care and appointments they had or are going to have throughout the year. The report also includes information on the efforts of the guardian to improve and maintain the ward's well-being. In addition to this actual report that's filed with the court, you must also obtain a physician report from the ward's physician. The physician report reports on the ward's current mental and physical status, and the physician will also include his opinion as to whether, based off of the ward's current status, whether a guardianship is still necessary, or whether he thinks maybe the court should inquire into the ward's capacity. In addition to an annual guardianship plan, guardians must also file an annual accounting, and this annual accounting is filed by a guardian of the property. The annual accounting is, like the title says it is, it's a detailed accounting of the ward's property. So it reports to the court on how assets and funds were used throughout the year in the guardianship and what assets and funds came into the guardianship. So those are the two main reports that need to be filed with the court each year. You wanna add something?
And you should be aware, and those of you who are in guardianships know this, that for historical reasons, I'll use that phrase again, we have this very long guardian of the property report, which for your adult child may require an entry of information on one page where we would advise the court that her only asset is SSI benefits that add up to some number of dollars per year. And that's it. That's it. And why did we need page after page with zeros on them? Go back to my comment about why we have guardianships in Florida and what the procedure is designed to cover. It's because they're trying to keep track of people who do have assets. And we don't anymore have a short version of the report that we can file. Not patting myself on the back, but many years ago, I devised a short form for the many, many guardianships, but that short form is no longer acceptable. They need this, what do they call it, Karina, with
a smart form.
Smart form, which is, as some of the judges have commented, actually quite dumb, because it's the same form for everybody, no matter what the facts and circumstances are. But they just don't seem to be able to individualize things down at the courthouse. Another aspect that is important once a guardianship is set up is thinking about the future. And Karina is going to describe our best efforts at that.
Yes. So this is not a requirement by the court, but it's something like Mitchell said that we recommend for clients in planning for the future. So that is to nominate a successor guardian. Successor guardians are people that are appointed as guardian if the currently serving guardian is unable to serve, which is usually because they pass away, they become incapacitated, or for some reason they're removed as guardian. So this successor guardian will then step up to be guardian. So this, the document that we prepare is called a nomination of successor guardian. The document states the current guardian's wishes on who he or she believes would be best fit to act as guardian if they are no longer able to serve. This nomination document is not filed with the court as soon as it's signed. It's a planning document that when the time comes that the currently serving guardian can no longer serve, we then file that document with the court along with the usual documents that are filed. So a petition to appoint a successor guardian and a guardian application, like I previously mentioned, along with fingerprints. So this nomination of successor guardian document is not determinative on who will be appointed as guardian, but it does show the judge that is reviewing this case on who the currently serving guardian thinks will be best able to serve as guardian. So the ordinary pleadings and documents to the court are still needed along with a hearing, but this nomination of successor guardian does carry some weight when the judge is making a decision on who should be appointed as successor guardian.
And in fact, it carries a lot of weight. The judge is happy that somebody has showed up to be guardian for this mentally ill adult. And in my experience, the judge is overjoyed that somebody's thought about this problem and put something on paper that can guide the judge in making the decision of the day, who will serve next. There is a procedure where you can file this with the court. We rarely use that procedure because after doing that a few times in the 80s and 90s, we discovered that even if you got permission now and approval now of your successor guardian, that number one, in many families, things change long before you need a successor guardian. And number two, even if it is the same person 20, 25, 30 years later, that person still has to go through the paperwork that Karina described, because whatever was the case back 30 years before, if you got approved in 2022 and you weren't going to serve till 2052, the court wants the whole thing refreshed, so to speak. And so you maybe your fingerprints are the same, but where you live and what you do and all of the things that fit into the application, all that needs to be redone. So what was the point of filing it 30 years before? I can think of occasional reasons why we would do that, but for the most part, in planning situations, we don't. I want to close by referring to planning for a moment. No, because Karina wasn't here at the time, but the office got into guardianship work for these adults because planning questions came up in the context of doing wills and trusts for our clients. You should address your guardianship questions in the context of your overall plans. That's not the subject of this talk, but when you sit down with the attorney who is doing your planning, you should ask her how guardianship would work in the context of your planning and what to do about coordinating the existence of a guardianship with your documents, your wills, your trusts, and other type of documents. Karina concluded her remarks a moment ago by talking about this nomination of successor guardian. That's where and when that question comes up. And you should be asking, is the person I'm nominating as successor guardian the person I want to be serving as trustee of the assets that I managed to leave for the benefit of that child? Or do I want different people? And when do I want the same? I mean, each family, each situation is different. And there's lots of factors that go into those considerations, and we're not addressing them now, but you should be addressing them at the table in your attorney's office with her as you go forward. That is really a good place for us to end. We could go back through all of these and talk more about them, but I think the plan is for us to entertain some questions and struggle to give you some useful answers. Thank you for your attention. You were a lovely audience. None of you fell asleep, except I can't really tell from the screens that I don't have pictures, but everybody does seem to be still moving who was moving before. That's a good thing. Jay, thank you.
Thank you, Mitchell, and thank you, Karina. I wanted to, this was so informative and great information that I'm sure that we'll have a lot of questions. But I wanted to make sure if anybody has any questions, they can raise their hands and you're welcome to ask. I'll be happy to see if anybody has any messages or any questions. Daniel.
Yes.
Yes.
You can hear me fine?
Yes.
I put a question in the chat, but I'm not sure if it got. But to request one of these petitions, does the individual first need to have a formal diagnosis of by a professional psychiatrist, psychologist, or either mental health condition or combination, maybe substance abuse problem? Is that a requisite?
So no, it is not a prerequisite. There is nothing in the petitions that are filed with the court that says, see the attached doctor's report. However, Daniel, if there is considerable doubt whether there is a mental illness going on, then maybe this isn't the right procedure to use to solve the problems of the day. I am very aware through my work with this population over the last 40 years that diagnoses are fuzzy on occasion, change on occasion, inconclusive on occasion, and that these reports, I'll tell you what that they're not always reliable to make plans to go forward or even to make plans in a guardianship. What I ask my clients to do, Daniel, is to bring me an evaluation that she or he or they, the parents, think properly, as completely as makes sense, characterizes the strengths and weaknesses of their child. Has there been such an evaluation? If there has, bring me that report. And that's often the basis. We may not attach it as an exhibit, as we say, to the petition, but we have it on hand to provide to the doctors who are appointed in the examining committee if we think it will be of help. And there are cases in which we think it will be, and we do make that report available. But there's no legal prerequisite.
And just to summarize that point, then it could be the family that develops this summary or this, I guess, record of, the person's behavior or challenges, issues. Is that what you said? The family member could actually compose this of their loved one that's, going through?
No, I wouldn't. I mean, I'm happy to read such a document composed by the family, and many families do have that letter or email or summary, but I would be looking, when I'm asking that question, find me in a report. Is there a report? This is a report prepared out of a psychiatrist, psychologist, clinical psychologist, neuropsychiatrist, any of the neurologist, hospital discharge summary, lots of places where you get paperwork. And I would want to see if anything professional, letterhead, signature fits into a good description of somebody's strengths and weaknesses. Mental illness is not easy. when you start looking for useful reports. There's often a complete gap, and you know, we just work with what we have. Again, I'm always trying to figure out how we can avoid guardianship, not jump in to a guardianship.
Thank you.
So I know Edith has a question, and we have a question in the chat. So Edith, if it's okay if I use the question in the chat and then I can turn over. Perfect. Thank you. So someone in the chat is asking, how much does a guardianship cost and how long is it in effect?
I like the second part of the question better, but I'll address both. A guardianship is in effect forever until the individual either dies or there is an effort to restore their rights and their capacity under the law. Karina and I are actually working on a restoration of capacity case right now. Doesn't come up that often, but an adult who had been found incapacitated during a time when he was having a lot of troubles and not functioning well. We weren't involved in that case when that happened, but she's come to us. He's come to us now, and he's talked to us, and his physicians have talked to us, and we feel that the guardianship is no longer needed. Maybe help and support is needed, but we're going to put together a plan, and we are doing that, and we're going to have a hearing at which the doctors and the people involved will testify that this gentleman no longer needs the structure of a guardianship. The first question about expenses and fees is a good one because it's always asked, so it must be a good question. The first part of the answer is that the court has its own fees and costs to get in the door, and they add up at this moment to about $750. Legal fees. Our office at this moment today is charging $3,500 to include an initial conference and all of the work up through the initial plan and inventory in the guardianship. That covers our time and work to do everything that is needed. And that is for a guardianship in which there is no controversy, in which everything is going to proceed smoothly. You say, well, that's a lot of money. Well, you only do that once. You only initiate the guardianship once. We also, because our name is now in the court file, take the annual reporting that Karina described. We take it very seriously. We not only keep track of it, but we sign off on it. And when I say sign, we sign. And there it goes to court from our office. And so we do have fees involved on an annual basis. Those fees we try to keep to the absolute minimum, working with the clients. We have a paralegal, happens to be my wife, who manages that whole guardianship reporting practice. But there are many occasions in which other legal matters arise. And based on the time that's involved in those other legal matters, we do charge fees, and we have an hourly rate. And my hourly rate is $450 an hour, and Karina's hourly rate is $300 an hour, and we keep track of our time and we bill accordingly. I have no doubt that there are attorneys who charge less. I have no doubt that there are attorneys who charge more. So you may want to call around, and I urge you to do so. But when you are calling, please make sure that the people with whom you decide to work have experience working in guardianship matters with adults with mental illness. Just that's where you're at. You do not, well, you may have other problems in your family, but this lecture is not about the 87-year-old person who has developed dementia and no longer is paying her power bill in the house in the West Gables or, you know, someplace else, something else. That is a set of problems. Guardianship lawyers do that work. They do a fine job given that part of the guardianship law, but that doesn't give them experience working with your 27-year-old son who has schizophrenia. Anybody brave enough to ask another question? You notice that my answers are always long, and that's part of what you have to deal with if you deal with me.
So we have Edith that does have another question, and then we have another question in the chat, but Edith, go ahead and then we'll do the question in the chat.
My question is this, I was warned about guardianships because I understand that makes you legally responsible for what your schizophrenic daughter does. And, you know, if they took the car and had an accident, if they, I got a letter in the mail, it looks like my daughter may have set up the corporation, how, I don't know. She was overdrawn in her able card account 61 times yesterday. I mean, at what point are you responsible for, you know, are you legally responsible for what she does?
So the law starts by saying, Edith, that you are not legally responsible. It says you are not financially responsible for the debts of the ward. But I have to tell you that I am cautious. I have no case law. I don't do personal injury. We don't do negligence cases. But if, just to give you a sort of a egregious example, if you are the guardian and you are the plenary guardian and the authority to have a driver license has been taken away from your ward and it can't be delegated to you because, as Karina pointed out, you can't have your child's driver license. There are some rights that you can't do, like getting married or voting for your child. But then you do allow your child to have a driver license, and you do, even, we've had this case, pay for the car insurance. If there's an accident, I think a somewhat assertive, aggressive personal injury lawyer is going to go past your child and ask questions about what you did as guardian, how you facilitated, enabled this situation where someone who had poor judgment was allowed to drive and was allowed to have an auto, luckily with insurance. These are tough questions. This is, I use that as an example. The overdrawn accounts may be a little easier, but Edith, if this goes on and on for months, I've never heard of a bank reaching through the ward to ask for payment from the guardian individually. But I could think of a contract situation, a landlord-tenant situation, where the financial party that was supposed to get paid could look to the guardian as, we would say in some situations, the guarantor. I could see that. So carefulness, reevaluation, ought to surely be in order. You do need to protect yourself in these, and this happens in these guardianships with high functioning mentally ill adults. Yes, you can call up the Division of Corporations, get the forms and open a corporation, even if your right to enter into contracts, your right to manage property has been taken away from you. You can do it because no one will ask. You as guardian could cancel it, but they can initiate it and they could have a guardian, have a corporation. And how would you know? How would you know?
I will back up and say, because it was an able trust card, they just don't pay it and there is no repercussions, and she doesn't even lose her card. So, but you know, it's that type of problem that
right. I mean, the able program is not going to come and raise a claim against you. But you know, they just don't get paid. Whoever the vendor is doesn't get paid. The vendors might start to have a problem if they're abused or they consider themselves to have been abused. I've not run into it, but I sure talk about it with a lot of Guardian clients. Celia?
Yes, okay, so thank you, Mitchell. So we have a couple of questions more. So one is, and we have two that are very similar. So I'm gonna combine them so that maybe you can answer both in one response. So the first one is, does the same thing apply if someone has a 100-year-old mother, or is it enough for the daughter to have a power of attorney? The other question is a power of attorney good enough instead of a guardianship?
Karina, you have some thoughts?
Sure. So it depends on the person that you're seeking either the guardianship or the alternative of a power of attorney for. So we, in Florida law, and we always suggest the least restrictive means. So if a power of attorney is sufficient, for example, for the 100-year-old mother or grandmother, if the power of attorney is sufficient to deal with your mother or grandmother's financial matters or personal matters, such as dealing with their doctors or any other type of medical care, then if it's working for you, then we would recommend that you continue on with this power of attorney, with the power of attorney documents and any other estate planning documents that she may have already in place. But if you go into a bank and you have a power of attorney document and they're not allowing you to access her accounts or to transfer money or to pay bills, then that may be a time when you should seek an attorney to get their opinion on whether your mother's in a situation where a guardianship would be needed because you're having difficulty either with her finances or with her medical care in general.
Okay. As a clarification, they're asking, like, how about if they have their child that's 27 years old? So we had the elderly parent. Now we have the adult.
I believe the same thing would apply. So if the young adult does have power of attorney documents in place that names the mother or whoever it is that's caring for him or helping him, then if those power of attorney documents are enough to seek him medical care or to deal with his finances, then you should move forward with those estate planning documents like a power of attorney. But if, same thing with a mother, if you are hitting a brick wall that you can't do something to help him or her, then maybe, again, you should contact an attorney to see, based off of the 27-year-old, how he's doing in his capacity, whether a guardianship is needed. Because other than the power of attorney assisting to care for him, a guardianship is also for someone that's incapacitated. So he would also have to meet that element of being incapacitated for a guardianship to be sufficient for him or her.
I think
Right.
You'll also find sometimes that there might be a way of enhancing the success of the durable power of attorney as the strategy of getting things done. We've had some experience over the years. We like durable power of attorney documents. Sometimes you can work with a financial institution or corporation that you're dealing with to improve the likelihood, to persuade them to rely on that power of attorney. So not always, but we would want to give that a bit more of a try before we abandon it. I will say that powers of attorney are respected a great deal more than they were 35 years ago. There's just more familiarity with them, but they still do run into problems and limitations.
Okay. Thank you very much. Valerie, before you ask your question, can I get to one more question in the chat? Okay, thank you. So someone asked, what happens if you don't do the yearly filing?
So if you don't do the, Mitchell, I guess I'll answer it. If you don't do,
We know about this.
if you don't do the yearly filings first, the judge will issue a hearing. The judge will schedule a hearing on an order to show cause because the annual reports are not filed by the court. Under Florida law, each year, depending on what county you're in, there's different timeframes and different dates on when the annual reports need to be filed. But if you don't file it by that time, they usually give a few days after the due date, but then they'll issue an order to show cause, which essentially is a hearing that you'll have, that your attorney and you would have to appear at to explain to the judge why you have not filed the annual reports. And even after that hearing, if you don't file the reports, then the judge can issue an order of contempt of court for you not following the law and your duties as a guardian to file the annual reports with the court.
Okay.
Theoretically, the court could really change things unilaterally if you sort of walk away from the situation. Your attorney is going to pay a lot of attention to this because she is going to know that if she can't deliver this report, that the court's going to get upset with her, along with you, but she's got to do business in the court, so she's trying to avoid being on the wrong side of this judge, probably. I mean, we surely do try. And there are things, look, we've got lots of these guardianships, and therefore some of them run into problems. Karina described this physician's report. That turns out to be one of the most problematic pieces, getting your child to get a doctor's letter, because the doctor has to see the child, or now telehealth helps. And so sometimes we have to file a petition saying we can't get to the doctor till another month from now, so please give us an extra couple of months to get this report in. It's a bit of just a difficult set of procedures that overlap, and it's part of the challenges and part of why we try to avoid the need for guardianship if we can.
Okay, Valerie?
Sorry, I just wanted to clarify what paperwork I would need in the event of my son is in agreement that I should be able to make medical decisions for him in the event that he should be admitted to the hospital for a mental health issue. Is that a durable power of attorney? Is that the paperwork I'd need? I'm a little confused.
So there is an overlapping set of documents that is anticipated in Florida law, Valerie. You can proceed with a durable power of attorney that confers healthcare powers on the agent, or, and in fact, and you can also have a designation of healthcare surrogate, which under a different statute says if I'm incapacitated, my surrogate can make medical decisions for me.
Okay.
You might want both because you don't know to whom you are going to be handing it and what that person, that stranger, will want at that moment or be persuaded by. You don't know. And there is a separate set of problems with psychiatric care. And that's different than fixing a broken leg. That's different than a colonoscopy. They're just,
Right.
Psychiatric care is treated differently. And there is discussion in the people who do what we do about having powers of attorney that turn over psychiatric care decisions to someone else. But the hospitals and psychiatrists are very wary of such documents when the individual says, that's not what I'm prepared to do. Well, you signed this document back 2 years ago. Well, I'm not going to do it now. Well, you're going to have a hard time finding a hospital that says, we don't care what you say now. You, this legally competent individual sitting in front of me, but 2 years ago, you named your brother as the surrogate to make medical decisions for you. And he says you should be given this injection of psychotropic medication, even if you don't want to.
I think
Very,
my-
very difficult.
Sorry, yeah, my experience in the past has just been that they are very unwilling, once you have somebody, as you say, over 18, they're very unwilling to discuss, especially if somebody has admitted himself, if he has been, my son has been Baker acted and also voluntarily gone into psychiatric facilities. He's great right now, doing very well for several years, but I don't want to meet that kind of, it was just so difficult at the time because they didn't want to discuss anything with me. Like, I'm his mother, but at the same time, they said, oh, he's competent, but he really wasn't. And he wanted me to be involved. But
If he
they would
wanted you
all-
to be involved, if he
Yeah.
wanted you to be involved, he could tell the provider that. And I hope at that moment, the provider, using some common sense and not listening to that provider's own attorneys who were warning them about liability. As I said earlier, attorneys cause a lot of these problems. The provider would, using common sense, talk to you. But I can tell you that they are reluctant in many and refuse in many situations. And just because the theme of this evening's presentation is guardianship, it's worth taking another minute and saying, well, what if you, Valerie, had the guardianship document there with you? Doctor, I am guardian. I was appointed by the court in 2017 as the plenary guardian of the person and property of my son. And based on that, you should speak with me. I think at that moment, even over the refusal of your son, I don't want you talking to my mother, that you have the authority to obtain information, to ask questions and see records and get information as guardian. Move to the next level. Doctor, I am the guardian of the person and property. I was appointed in 2017. Here's the letters of guardianship. You must now give my child that injection. And I think that that court is going to, not court, excuse me, that doctor is going to be very reluctant, and I can't speak for the doctor, but to give that injection in a voluntary hospitalization, when the patient says no. Go to the next level. In an involuntary hospitalization, you as guardian lose your authority. The run-of-the-mill guardian, everyday guardian, does not have the authority to involuntarily admit the ward for psychiatric care. There is an exception in the statute. The history of that exception is interesting, so I'll tell you. It's because for many years back in the old Soviet Union, the evil empire days, people were involuntarily committed to psychiatric institutions in the Gulag. And so we in Florida passed an exception to our to our guardianship law that said guardians cannot put their wards in psychiatric facilities involuntarily without going back to court and having a full dress hearing where your child is represented by counsel and experts are called to prove that that involuntary hospitalization for psychiatric treatment is in the best interest of your child. A tough hearing. Baker Acts are the way in which this happens. And again, going back to Karina's comment on the guardian advocate in the Baker Act proceeding, and you didn't create the Baker Act because guardians can't create the Baker Act. The Baker Act has to come from another source. The court in the Baker Act proceeding will appoint someone called the guardian advocate, and it can be you, but not you as guardian. It can be you as an individual. I don't think there's a problem with that. And in that, wearing that hat, you can consent to involuntary medication. You got in through another door, but every one of you, if you've been through Baker Acts, know that they are not the panacea. They are not the answer with a capital A. They are a rough procedure which sometimes results in beneficial treatment and oftentimes just results in a couple of days in a hospital and back out into the community.
Right, thank you.
Well, I think we're good with questions. So I wanted to thank again Mitchell and Karina for joining us tonight. This was so helpful and so informative. You guys did an amazing job at demystifying and simplifying some of these laws and options that we as loved ones and family members have, which really we never want to have as a recourse.